The copyright law states that initially the author of a work is considered the copyright owner. We care about whether or not a work is a work made for hire, because in the case of a work made for hire, the author is considered to be the employer or other person for whom the work is prepared. If they are considered the author, they are, under the copyright law, the rights owner. They own the copyright. In order to determine whether or not a work is a work made for hire, we have to engage in a two-part inquiry. Part one is whether or not the work is created for an employer by an employee within the scope of their employment. If there's an employer-employee relationship based on a consideration of all of the factors in a particular case, the employer will be considered the author and therefore the copyright owner. Another type of work made for hire is work that is specially ordered or commissioned. In the case of specially ordered or commissioned work, there are in turn two requirements to qualify for work made for hire. One of the requirements for specially ordered or commissioned work is that the work be created under a written agreement signed by the author stating that the work is or shall be considered work made for hire. If there's no written agreement, the other requirements for a work made for hire for the work that is specially ordered or commissioned are irrelevant. But if there is a work made for hire agreement in writing for the specially ordered or commissioned work, we have to determine whether or not the work falls within the categories of works that are recognized as works made for hire. These include an atlas, a test, answer material for a test. They also include a translation. They include supplementary work, contributions to collections, compilations, and audiovisual work and motion pictures. If your work falls within one of these categories and there is also a signed work made for hire agreement, then it can be classified as a work made for hire, in which case the person or company for whom you prepared the work would be considered the author and therefore the rights owner. Unlike the work made for hire that is an employer-employee work made for hire, which requires no written agreement, a specially ordered or commissioned work will require that the written agreement be provided specifying that it is a work made for hire if it's to meet the terms of the statute.